Respected ma'am, I'm Anchal Agarwal, pursuing B.LLB from Gemtech School of Law. I'm going to present a case study on Jacob Mathew versus State of Punjab and another. The objective of assignment is to determine the difference between civil and criminal law in the concept of negligence and also whether a doctor or a medical practitioner has breached his duty regarding the care of the patient. Outcome of the assignment is to prosecute the medical professionals for negligence under criminal law. Something more than mere negligence had to be proved. The title of the case is Jacob Mathew versus State of Punjab and another. The bench comprises of Chief Justice of India R.C. Lahoti, Justice G.P. Mathur, Justice P.K. Balasubramaniam. The citation is AIR 2005. The parties: petitioner is Dr. Jacob Mathew, respondent is State of Punjab. The laws involved are Section 304A of Indian Penal Code, that is, causing death by negligence, and Section 34 of Indian Penal Code, that is, common intention for criminal activity, in which all people included to be held liable. The brief facts of the case are as follows. A patient named Jeevan Lal was admitted to a private ward in CMC Hospital, Ludhiana at 11 p.m. on 22nd February 1995. The patient suddenly felt difficulty in his breathing, and his elder son Vijay Sharma called the nurse and the doctor as soon as possible. No doctor turned up for about 20 to 25 minutes. After that, Dr. Jacob Mathew and Dr. Alan Joseph came to the room for the patient. The patient was immediately connected with an oxygen cylinder, but still the problem is increasing. Further, the oxygen cylinder was found to be empty and no other oxygen cylinder was available. Then Vijay Sharma went to the other room and brought another gas cylinder. In between of this, around 5 to 7 minutes were wasted. During this, the doctor confirmed that the patient is dead. Further, the younger son, Ashok Kumar Sharma, filed a FIR under Section 304A, read with Section 34 of Indian Penal Code. The procedural history. According to Dr. Jacob Mathew, the patient was already suffering from advanced stage of cancer. The family was consulted to keep the patient at their home and give proper nursing, but the sons, being some influential person having occupied position in government, requested the hospital to keep the patient under their care, and the patient was admitted to the hospital. Issues were: is there a difference between civil and criminal law in the concept of negligence? Second, is there a test to determine the negligence level through which it will be decided whether the doctor is held liable for the negligence or not? Arguments raised by the petitioner. No professional doctor would try to hurt their patient, as it is their responsibility to cure and heal the patient, as their reputation is on stake. A single failure may cause them a huge impact on their career. A medical practitioner takes full responsibility of the patient and hence does not get anything out of negligence or the omission caused. Decisions taken by the lower courts. The Judicial Magistrate First Class Ludhiana framed charges under Section 304A IPC against the two accused persons, both doctors. Then both of them filed a revision in the Court of Session, but the revision was dismissed. Further, the appellant filed a petition in High Court under Section 482 of Criminal Procedure Code, that is inherent powers of High Court, praying for quashing of the FIR and all the subsequent proceedings. But the learned single judge who heard the petition formed an opinion that the plea raised by the appellant was available to be urged in defense at the trial, and therefore the High Court dismissed the petition. Feeling aggrieved by these two orders, the appellant has filed these appeals by special leave petition. Now the judgment which came up by the Supreme Court, it was held that the, it is not the case of complainant that the accused was not a doctor qualified to treat the patient whom he agreed to treat. It is a cause of non-availability of oxygen cylinder, either because of the hospital having failed to keep available a gas cylinder or because of the gas cylinder being found empty. Then probably the hospital may be liable in civil law, but the accused appellant cannot be proceeded against under Section 304A of IPC on the parameters of Boehm's test. Boehm's test is the test which is carried out to determine whether a doctor or a medical practitioner has breached his duty regarding the care of the patient. The Boehm test was established from the case of Boehm versus Frayne Hospital Management Committee. Hence, the appeal are quashed. The prosecution of the accused appellant under Section 304A read with 34 is quashed. The Supreme Court gave the guidelines regarding prosecuting medical professionals as follows. Before proceeding against the doctor which is accused of rash or negligent act, the investigating officer should obtain a medical opinion, preferably from a doctor in government service of same branch, which can be normally not be impartial and unbiased. Secondly, a private complaint may not be entertained unless the complaint has produced prima facie evidence before the court. Thirdly, a doctor accused of rashness or negligence may not be arrested in a routine manner simply because a charge has been leveled against him unless his arrest is necessary for furthering the investigation or for collecting evidence. The conclusion. It can be stated that to prosecute the medical professionals for negligence under criminal law, something more than mere negligence had to be proved. Medical professionals deal with patients and they are expected to make the best decisions in the circumstances of the case. Sometimes the decision may not be correct. That would not mean that the medical professional is guilty of criminal negligence. Such a medical professional may be liable to pay damages, but unless negligence of high order is shown, the medical professional should not be dragged into criminal proceedings. Further, it can also be stated that in the case of criminal negligence against a medical professional, it must be shown that the accused did something or failed to do something in the given facts and the circumstances of the case which no medical professional in his ordinary senses and prudence would have done or failed to do. Thank you.